In the last episode, we explained why relevant market is the basic tool of competition law. One of the main reasons is simple. Without a properly defined market, it is very hard to say whether a firm is merely large or whether it actually holds a dominant position. And that distinction matters because modern competition law is not really about punishing size. It is about understanding when market power becomes legally relevant. A famous starting point is Alcoa. In that case, the court made monopoly power the central issue of the analysis. But the law later evolved, especially outside the United States, in a more refined direction. The clearest modern approach is this. The law does not prohibit dominance as such. It prohibits the abuse of that dominance. That is exactly what Article 102 of the TFEU says, and the same logic appears in the Andean Community's Decision 608. So the legal question is no longer just, is the firm big? It is, does the firm have power over the market, and is it using that power abusively? The legal definitions reflect that shift. Under European case law, a dominant position is a position of economic strength that allows a firm to prevent effective competition and to behave to an appreciable extent, independently of competitors, customers, and ultimately consumers. In Colombia, Article 45 of Decree 2153 of 1992 defines dominant position as the possibility of determining directly or indirectly the conditions of a market. And Decision 608 develops the idea even further. It says there is dominance when one or more firms can substantially restrict, affect, or distort the conditions of supply or demand in the relevant market without competitors or consumers being able to counteract that power in the short term. That is why concentration is not the same thing as dominance. A market may be concentrated without any one firm being dominant, and a firm may have a large market share without being able to behave independently of competitive pressure. The European Union has often treated concentration as an important path toward dominance. In AKZO, the court said that, save in exceptional circumstances, very large market shares are in themselves evidence of dominance, and that a 50% share may be enough. So in Europe, concentration can be a strong signal. But even there, it is still a signal about power, not the whole story. The United States now makes that point even more clearly. In the recent Meta case, the court rejected the FTC's monopolization claim because it found that Meta had not been shown to hold monopoly power in the relevant market. The court looked not only at shares, but at substitution, user behavior, competitive pressure from TikTok and YouTube, and real-world evidence of how consumers switch. So the lesson from Meta is that dominance or monopoly power is ultimately a qualitative concept. It depends on market realities, not on concentration numbers alone. In Colombia, the logic is very similar. Article 45 gives the short legal definition, but Decision 608 explains it better. Dominance is about the real ability to affect market conditions in a substantial way without effective counterpressure from rivals or consumers. That means Colombian law, like European law, does not reduce dominance to a simple percentage. It asks whether the firm can actually shape the market. And that is why concentration and dominance are measured with different indices. HHI, or the Herfindahl-Hirschman Index, measures market concentration by squaring each firm's market share and adding the results. It tells us how concentrated the market structure is as a whole. The Stenbacka Index is different. It is designed to assess dominance, meaning whether a particular firm's share is large enough to classify that firm as dominant. So one index is market-wide, the other is firm-centered. That alone shows the core point of this episode. Concentration and dominance are related, but they are not the same thing.